Kubikian. I'm an attorney at the Herzog law firm. And from time to time, I'm just going to click to make sure you guys can hear me. I apologize that this may not go perfect. I am from the Herzog law firm, and I'm one of the attorneys. I have two partners, Debbie Verney and Jay Marie Schaefer. And many of you do know Harry Miller, who is one of our attorneys as well. And the full name of the firm is Herzog, Engstrom, and Koplowitz. And that wouldn't be the full name of the firm without Mr. Sholem Koplowitz, who I understand is joining us today. Hi, Sholem, how are you? So we do seminars. We do seminars in, in the capital region, pretty much every county around here. And we usually are talking about estate planning or elder law. Sometimes we're talking about some pretty nitty-gritty Medicaid planning called crisis planning. And every now and then we do this topic, which is called wills versus trusts, which is one of our more popular topics. And it's where there's a lot of bad information out there as well. So we have people who think, for example, that if they have a will, they don't have to go through probate. Not exactly true. Well, we have people who have a trust and they think that they can never touch it or change it. And that may be the case, but usually when they're doing a type of trust that we do, it's just not the case. And they can access their own money. They can be the income beneficiary and so on. So what we're going to do today is we're going to talk about basic estate plans, and we're going to get into wills, obviously, and then start to talk about something called probate and why you may want to avoid it. And then we'll get into a revocable trust, Medicaid trust, and then we'll compare and contrast, and we'll see how it goes. If you have any questions, at the top of your screen, you should be able to click on a chat. Or so if you're looking at your screen, you go up and you see the words more with 3 dots. You can click on that and you can chat, and you can chat with everybody. And we do have Kim Hance from our firm. Kim is one of our geriatric care managers. She'll be able to look at the questions, and she can text me. She can post something for me to look at so I could address some of your questions. Now, we do have a lot of people here. We're supposed to have almost 100 people on this chat. So if you do have questions and I don't get to them, please feel free to email me or email us at the firm at info@herzoglaw.com. That's HERZOGLAW.com. Or you can email me specifically, dkubikian, KUBIKIAN @herzoglaw.com. You could always call our office for a consultation as well, and we'll go from there. So here we go, wills versus trusts. Let's go. As long as I can get it going. There we go. So everyone really should have an estate plan if you're 18 years or older. And we define estate plan as being as general a definition as you could think of. So it doesn't mean everyone needs to have a trust. It doesn't mean everyone needs to have a will. But you should have something, okay? Why? Well, because you might have incapacity at some point in your life. There might be a disability for you or a family member sometime in your life. And guess what? We're all going to die one day. So certainly we know there will be death at some point. And we want you to be prepared. We want you to have documents because, believe it or not, you have a lot of control now and in the future as long as you have documents in place. Sometimes the point is to avoid unnecessary procedures. For example, if you have a power of attorney, which we're going to talk about in the slide here, slide or two, that can avoid a guardianship. A guardianship is where we get the court involved to take away someone's power. Grandpa can't manage his finances anymore. He doesn't have his mental capacity anymore. He has a power of attorney. Well, we have someone in place who could do that for him. But if he doesn't, we may very well need to go to the guardianship route and go through the surrogates court or the Supreme Court in your county to get a guardian to be named to actually take powers away from grandpa as opposed to also being able to act for him. When it comes to your basic estate plan, it really involves 3 or 4 documents: the power of attorney, healthcare proxy, and the last will and testament. Now, power of attorney, as I mentioned, is where we can name someone during our life to be able to do things for us when we're unable to, or we're just not feeling up to it. For example, it could be because someone lost their mental capacity. They are going through dementia and they no longer can handle their finances. If you have a power of attorney, you can name someone to act for you. It doesn't have to be so doom and gloom, though. It doesn't have to be waiting for some sort of incapacity like that. On 9/11, my parents were not in the country. They were in England. And guess who couldn't fly back from England after 9/11? That's right, my parents. And they had a business and they asked if I could do X, Y, and Z for it, and I couldn't. I was an adult, I was 18 or older, but I wasn't their power of attorney yet. And so as a result, I had no way of doing things to help their business out, right? They were the only signatories. So there's a lot of practical reasons why you do want to have a power of attorney. And in our opinion, everyone 18 years or older should have a power of attorney. And who that agent is, who is able to act for you, that changes over time. So, you know, it doesn't have to be your 19-year-old kid. It could be one of your siblings. It could be one of your friends. As time goes on, it's certainly possible for you to change your power of attorney to name it your children, because now they're mature and they're adults and they're parents of themselves. If you don't have a power of attorney, if you haven't been proactive, that's where we run into trouble, because we're going to need that guardianship, as I mentioned. In addition, now, usually I'm used to doing seminars in front of people where I could say, you know, I show of hands, how many people have a power of attorney out there? So I kind of get a feel for who has what. Obviously, we can't do that today. So I will say, if you do have a power of attorney, take a look at it. For most people, they haven't looked at their power of attorney in a really long time. And it's terribly important to make sure you still like those people who are your agent. They still are around and able to do their job. And also, it's really important that they have all the bells and whistles, all the powers that we want them to have. The name of the game is people having options, okay? No matter we're talking about trusts, wills, what have you, we want our clients to have the option to do whatever it is they want in life. And a power of attorney will give you more options down the road, because we don't have to depend on you having your mental capacity anymore. We need and can rely on our agents to do things. For example, when it comes to Medicaid planning and some pretty intense things like that, if we have an agent who has the ability to gift on your behalf with certain restrictions, we know we can move heaven and earth to get you qualified for Medicaid to save your family tens of thousands of dollars. And so it's terribly important, if nothing else, if you don't learn anything else today, take a look at your old power of attorney, make sure it still is up to snuff, and make sure that your agent has the ability to gift on your behalf, not take all your money, gift on your behalf in a smart way to perhaps set up a trust, or perhaps add more money to your trust, or engage an attorney to do some heavy duty planning. All right. Healthcare proxy and living will. So at our firm, we do a healthcare proxy and living will in one document. Okay, your healthcare proxy, pretty straightforward. We're naming an agent who can act for us. What can they do for us? Well, they can make healthcare decisions. They can interact with doctors. When can they act? Well, they can only act if you are incapacitated, right? The second paragraph of our healthcare proxy says, if I am unable to make my own healthcare decisions, that's when your agent may be able to act. When we do a healthcare proxy, we always want backups as well. We have contact phone numbers for our agents so they can easily be contacted. And we normally want a living will in our document as well. Living will deals with certain kinds of end-of-life decision-making. And while that's not a fun topic to talk about, the important thing for you to know is you control your destiny. I like options, I like control. I want my clients to have control. When you have a living will, so you're not designating someone to make decisions for you as much as you are making decisions yourself, and you're authorizing someone to relay those decisions to whatever medical professional is appropriate. All right, let's move on. So your will. So the basic part of your documents, let's go back for a second. We got a power of attorney, check. We got a healthcare proxy and living will, good. And then the last will and testament. So again, when we're in a class and I'm trying to be interactive, I'll ask, show of hands, true or false? How many people think it's true? A will says how all your assets are going to pass. And people kind of can sniff out when I'm trying to get them to say the wrong answer. So a lot of people will end up getting it right, but they actually thought the wrong answer, right? A last will and testament does not give all of your assets out to people. And there's a number of reasons for that we'll get into. Now, the will itself, there's a bunch of different varieties of them, and I'd say about 85% of the wills we do, maybe 80% or so, end up going into the simple will category, okay? That or a pour over will. Now, a simple will could be quite complicated. A simple will is really saying this document says directly who's going to receive my assets. And it may be that those people are receiving it in trust. It may be that there is a special needs trust that's going to be involved. Yes, you can. I just saw a comment. Can you get a copy of the PowerPoint? Yes, we will provide a copy of the PowerPoint to everyone as soon as the seminar is over. Okay. So simple wills, as I mentioned, could be really, really complicated. It could involve all sorts of trusts within your will. More often than not, we're using something called a pour over will, and we use that in conjunction with a trust. So if you end up doing a trust with our office, we will normally do a will for you that takes into account the existence of the trust. Really, we have your will pour into the trust. And there's a number of reasons for that that we'll get into when we get to the trusts. Now, you ask around, right? People say you got to have an estate plan. Oh, wills are so important, but the vast majority of people don't have the proper estate plan, and a regular majority of people don't have a will to begin with. And there's a lot of different reasons for it. The good news is it's not too late when it comes to a will, because if I'm talking to you or you're listening to this, chances are you're still alive and you have the mental capacity to do a will right now. But as you'll see when we talk about estate planning, it's really about being proactive. And it's not just about the will. It's about protecting assets for later on in life. Okay. So your last will and testament, what does it involve? Well, there's a beneficiary. Sure, that's who's going to get things when you're not around anymore. There's an executor. That's the person who's going to make sure that whatever your wishes are happen. So if you say give $10,000 to this charity, the executor makes sure that that transaction takes place. Their job is to marshal all assets that belong to your estate, pay all appropriate creditors. They take some commissions and they give things out to whoever you wanted. The probate process. So this is interesting, right? I'm going to talk on both sides of my mouth. I'm going to be that kind of attorney that does that, because I want you to have a will, okay? And if you met with any of the other attorneys at our office, they'd say the same thing. We want you to have a will. But we really, really, really want you to never use the will. And people think that we're being sweet, that we're saying that we don't want them to ever die. As I mentioned, we're all going to die one day. So that's not what I'm saying. I'm saying I don't want your money to go to that charity. I don't want your money to go to your children because your will said so. Because that means that we have to go through this process called probate. The word probate is a Latin-based word. It's to prove. It's the proving of your will. And the probate process involves us notifying everyone who has the ability to contest your will, to fight it. We give them the ability to do so. We also give them the opportunity to waive in their right to contest so that your will be seen by New York State as, in fact, your last will and testament. And so the rules in there will apply. Now, probate, the proving of it, it's really to make sure that everything happened the right way, that everything was executed properly. What does that mean? Well, did you have the right capacity? Did you give everything to one of your daughters because she was sitting right next to you over here? You can't see her. And she was saying, I'm not visiting you. I'm not taking care of you unless you give everything to me, Mom. So the court needs to make sure everything was done the right way. For example, a power of attorney who can do a lot of things for you can't sign a will for you. We need to have two disinterested witnesses. We get this a lot when people go online and they do their wills, because they end up having family members be a witness. That's not okay. We got to make sure they're two disinterested witnesses, because they're going to swear to the fact that you had your capacity when you signed your document. And that gets us to an affidavit that would need to be provided. In short, there's about a dozen documents that we're going to provide to the court in your normal probate. That's not the part that stinks, right? Obviously, it's unnecessary to have these court fees and attorney's fees. Obviously, we don't want to allow people who don't like the provisions of our will an opportunity to contest it. But even if we have the easiest will where everybody agrees, the next 7 months is going to be a court supervised procedure. It's called a probate in the state administration. We allow your creditors up to 7 months to contest, to put a lien on your estate or make themselves known as a creditor. They're going to get paid. So if your family member went through Medicaid, Medicaid will put a lien on your estate, as an example. I want things to go to the right people. I want things to go wherever it is you want it to go, however you want it to go, okay? I just don't want to go through a will because it's unnecessary. The highest court filing fee for a will that you can have, the cap, which is a little over $600,000 estate, is $1,250. That's just to get your foot in the door at surrogate's court. That doesn't even get to people like me who are going to earn a fee for representing the estate. So big picture, your average probate is going to cost thousands of dollars, and we'd like you to avoid that while getting things to the right people, which is the most important, right? That is what estate planning is. Who gets what? Now, if you think you're going to get out of this whole estate administration by not having a will, because having a will sounds so complicated, think again, right? If you don't have a will, New York State will say where your assets are going to go rather than your will saying where those certain assets are going to go. And the rules aren't necessarily crazy. If you go to the second and third bullet point, seems to make sense. If I'm survived by a spouse and we didn't have any children that survived us or any children at all, everything goes to my spouse. Sounds about right. If I'm survived by children, but my spouse predeceased me or I'm divorced, makes sense. Everything I have goes to my kids. So far, so good. Gets a little more complicated. We look at that first bullet point. If we're survived by our spouse and kids, well, guess what? Your spouse doesn't get everything anymore. And now they're going to be co-owners of certain pieces of property or certain assets with their kids, which obviously is not what we intend. Worst of all, if you're not survived by children or a spouse, and we've seen this happen way too many times, we've had instances where we did planning for mom and dad, and eventually nature took its course and dad passed away. Mom ends up in a nursing home one day, and we did all the planning we possibly could have done. And then one of her daughters predeceases her. And that daughter dies will-less, spouseless, and childless, which under New York law means that mom, not the sisters, but mom inherits all of daughter's money. Mom is in a nursing home. So who really inherited mom's money? Daughter's money, excuse me, the nursing home. So it's really important that you have a will because it's important you decide where assets are going to go, okay? The problem with the statute, though, is that it's not very smart. And what I mean is that it doesn't say that your kids don't get money until they turn 30, right? I have a 6-year-old daughter. I have a son who's about to be 1. And if I didn't have a will and my wife and I both passed away, we have assets going to our kids at 6 and 1. Now, obviously, they're not going to put Toys R Us back in business at all. They may try. But they're going to get the money at 18, which is just as worse. Is actually worse, excuse me. Because at 18, they're an adult. I can't hold that money any longer. So if you're going to rely on the intestacy laws to get your assets to someone, it's a recipe for disaster because it's just not a smart way to do things. I don't want my kids getting money at 18, and neither should you. Now, I mentioned at the beginning of talking about wills, the theoretical question, true or false, our will says how all our assets are going to pass. And the answer is false. A will does not say how all our assets are going to pass. It's because we all own things that are called non-probate property. Probate property is property that's governed by your estate, your will in most instances. Non-probate property, though, passes outside of your will, outside of your estate. And this is a great way to avoid probate. I'm a big fan of non-probate property. So what are examples of that? Well, life insurance is a great example of non-probate property because my life insurance has a beneficiary, a death beneficiary, right? Retirement assets are the same way. You can name beneficiaries on those. Bank accounts can be TOD or POD, transfer on death or pay on death, which is a great way to move things to other people. Even more important, you could have jointly owned assets with rights of survivorship. That can be financial accounts. That could be real estate. In fact, if you own property, husband and wife, as a married couple, it's assumed that there's rights of survivorship. You own something with your brother, not so much. It's assumed that you guys each own half the property, unless you actually say that there's some what we call survivorship rights. So avoiding probate's fine. Right? That makes a lot of sense. Having non-probate property not counting the trust tends to make a little less sense. And let me give you an example. So obviously, look, if it's a contest between avoiding probate or going through probate, I side on avoiding probate every time. But in life, it gets a little more complicated than that, and I'll use myself as an example. So as I mentioned, I have a wife, and I have a 6-year-old daughter and a 1-year-old son. And I'll say to clients, I'll say to people at seminars when I'm actually able to interact with them, I'll say, all right, I have life insurance. My wife is my beneficiary. Who is my backup beneficiary on my life insurance? Every single seminar, people will say, your kids. And I say, you're crazy, because my kids are 6 and 1. Obviously, I don't want them to have money. Even if money's helped for them, again, they're at 18, they're an adult. I know all of you were 18 once. I know all of you were not adults when you were 18. Some of you probably were, but most of you weren't. So it's an awful idea for going to give money to kids at that age. So what do? Right? I want to avoid probate. Well, I tell this to a lot of my friends who are in similar situations, and I tell them, on your life insurance, name your estate as the beneficiary. So my wife would be the first beneficiary. The backup beneficiary would be the estate of David Kubikian. What does that do? Well, that puts all that life insurance money into the pile that's governed by my will. And my will say I give everything to my wife. If my wife predeceases, I give everything to my children. Typically, we use the word issue. So I leave it to my heirs. And not until age 25, not until age 30. I could put whatever restrictions I want in my will. And that's a great way to do it. Now, I'm going against something I just said a slide ago, right? Because that involves my will, that involves the courts, that involves probate. However, what's most important to me is that my kids don't get money at 18. So yeah, you know what? I might bite that bullet and actually go with a will that has all that language and direct my non-probate property to go to my will only in the event that my wife had predeceased me. Hopefully, obviously, that will not be the case. There's a better alternative, though. We could actually have these rules governing our money. We could actually take advantage of our non-probate property, and we could actually avoid probate, right? Rules, avoid probate, and otherwise take advantage of this non-probate property. And the way we do that is using trusts. And I think this will all start to come together a little bit, all right? So what is a trust? It's an excellent question. Thanks for asking. A number of different kinds of trusts, okay? The two main kinds are a testamentary trust or an inter vivos or a living trust. We've talked about testamentary trusts already. In fact, in my will, when I leave things to my wife, and if she predeceases me, I leave it to my kids. And then I have a couple pages saying, well, not until they turn 25, and you can give them this percentage at this age, that percentage at that age, and my brother's going to be trustee of this money for them until they turn this age. All of that language in my will, that's considered a testamentary trust. Remember, last will and testament, testamentary trust, right? Makes sense, testamentary trust. Wonderful, okay? If you have youngsters out there, if you have grandchildren, make sure that your children have a good will with good testamentary trust in them. Guess what? They still count as simple wills, okay? They're not expensive. But the language in there, if it applies, it means some pretty bad things happen, but at least it means money is going to be protected for our kids. It means that maybe we have some special needs language. We have children or relatives or beneficiaries with special needs. It could be that you don't trust someone to spend money appropriately, and we have it in there for that reason. Maybe it's an incentive to make someone go to a certain school, secondary school, or live a certain way. Who knows? Those are great, except to get to the language in your will, I got to go through your will. I got to go through probate. So better than nothing, but it can get a little better than that. That's where living trusts come in. And the idea of a trust is really like a box, okay? The rules regarding your trust are the rules of what goes in that box and how it comes out of that box. And depending on the kind of living trust that you pick, the rules will vary. And there will also be other consequences of that, as you'll see. So when it comes to revocable trusts, okay, that's I don't want to say this is where we have control, because you control all the trusts that we're going to talk about today. But this is where you, by yourself, with just your signature, right, can do whatever you want to do. This is the document that's most like how life is for you right now if you're sitting there trustless. With a revocable trust, it means that the creator of the trust, you, can revoke the trust. We're going to talk about what the word revocable means in a second. Okay, we'll do a couple slides on revocable trust, but then I'm going to really focus on what I want you to define revocable to mean. So in a revocable trust, there's someone who set it up. We call them the grantor, and that's you. You are the grantor of your own trust. In a revocable trust, typically the trustee, the person who's the authorized signatory for the trust, I don't want to say the person in charge necessarily, because yeah, it's kind of like a restaurant where the trustees are general manager and they're running the show a little bit, but they're not the boss, right? The grantor is the boss in a revocable trust. The trustee is the signatory though, and typically the trustee in a revocable trust is you as well. Okay, so you're the grantor, you're the trustee. And there's a beneficiary of your trust, and there's two versions of it, because during your life, when you're still alive, your trust is for your benefit. So you are the income beneficiary of your trust. So if you put stocks in there, you put rental property in your trust, you're getting the dividends, you're getting the interest, you're getting the rents, okay? Just like you always would be. And then eventually at some point, there'll be an end to your trust, typically at your death. And there's another list of beneficiaries, which are more in line with what you would see in a will, right? This is who gets the money at the end of the day, okay? Revocable living trusts, they're really handy, okay? Now, I'm gonna cut that off in a couple slides here, because I'm gonna tell you why another trust might be better for you depending on your age and circumstances. But this really gets the job done if what we're trying to do is avoid probate. This gets a job done if all we're trying to do is deal with a complicated family tree. For example, we have lots of clients who are in second relationships and second marriages with children from prior relationships, prior marriages. And so what ends up happening is they get remarried, and I treat her kids like my kids, she treats my kids like her kids, and that's wonderful. But if we rely on just a will where I say I give everything to my spouse and then to all of our kids, she does the same will. We call them I love you wills. After my death, anything's possible, right? She can make it so that her estate doesn't have any assets. She can do a new will. So typically revocable trusts will be used in more complicated family trees, because that's a way for us to guarantee a certain result for both parents, because they do have kids from prior relationships. So those are the two main times that we'll see the revocable living trust come into play. More often than not, though, the main trust we're doing is called a Medicaid Asset Protection Trust, which is more in the quote-unquote irrevocable range. So we got revocable, irrevocable, revocable, irrevocable. Okay, so what exactly does the word revocable mean? Because that's going to help us define what the word irrevocable means. And I'm going to play a little game here. You may throw something at your screen. I apologize in advance. So the word revocable means that you, who created the thing that's revocable, you, by yourself, with just your signature, can access the money out of your trust. You, by yourself, with just your signature. That's revocable. All right. Irrevocable. Your irrevocable trust. Now, at the seminars, again, I'm sorry this isn't as interactive as I'd want it to be. I would say to you, all right, yell out, what does the word irrevocable mean to you? And what most people yell out is things like, you can't change it. You can't undo it, right? You lose control. Wrong, wrong, wrong. At least when it comes to this kind of trust. Now, yes, the word irrevocable suggests that you cannot revoke something. Irrevocable. Well, let's go back to what revocable means, okay? Revocable means you by yourself. That's the key. You by yourself, with just your signature, can turn something into money. You can take everything out of your trust by yourself. Sorry. Irrevocable means not that. It doesn't mean we can't touch our money. It doesn't mean we can't break into this trust. It doesn't mean we can't enjoy our money whenever we feel like it, can't take it out whenever we feel like it. It just means we can't do it by ourselves. We need somebody else in order to get to our money. That's what irrevocable means. Guess what? You could still change and amend your trust if it's a Medicaid asset protection trust. You could still change your trustees in this kind of trust, as you'll see. You could fire your trustee, okay? Basically, as you'll see, if the people who don't agree with you are your trustee and beneficiary, well, we could fire them and replace them with people who are yes men, yes women, and I'll do whatever you want. The point is, I need to make sure that you can access your money. Now, I'm kind of jumping the gun here, and you're probably saying, well, why does this matter? And oh, by the way, there are kinds of irrevocable trusts which really are ones that you can't control and ones where you can't change things. But for our purposes today, we're talking about the kind of irrevocable trust where you can do all those things. And we use that for Medicaid. Now, why do we use that for Medicaid? What's the whole point? Well, until we're all gone from this planet, we're going to continue to get older. Every day we're one day older. And as we get older, our needs are going to change. And at some point, we'll have some long-term care needs. It's just the vast majority of our population will be in that boat. What are long-term care needs? Well, there's healthcare and there's long-term care. And whereas healthcare is you go to the doctor, you might get better. You go to the hospital, you might get better. You go to rehab, you might get better. Long-term care is really, you're not getting better. You're not going to be better, right? We have activities of daily living that we have problems with, and it's likely to not get better. We now have a bad hip, right? Healthcare, hip got operated on at the hospital. Healthcare, I did rehab for a little bit. Long-term care, I now have a bad hip, okay? And when we're living in that reality, whether it's dementia, whether it's physical ailments that are leading to our long-term care needs, the question is, how do we get our care? Where do we get our care? Who's providing the care? And the big one, how are we going to pay for it? How are we going to pay for your care? And that's where Medicaid comes in, because Medicaid is the largest payer of long-term care expenses in the country. Your three options are paying out of your pocket, long-term care insurance, or Medicaid, okay? So everyone talks about Medicaid when it comes to long-term care. Everyone wants to be qualified for Medicaid, excuse me, when it comes to long-term care, Medicaid. How do you qualify? What does Medicaid look at? Well, lo and behold, Medicaid looks at your assets, your resources, right? And they're only concerned with those assets that you own, where you, by yourself, or you and your wife, by yourselves, can access your assets, where you could turn a CD into cash, where you could sell a house and now you have a pile of cash, where you could invade your revocable trust with just your signature to pull out your own money and put it back in your own name. That's what they care about. They care about your resources. And because you have so much control in that revocable trust, because you do everything with just your signature, if it's in a revocable trust, it doesn't help protect your assets when it comes to long-term care. And that's why now it makes sense. Now it's a really good idea that we can do a Medicaid trust where we still control everything, but we're not the only person who needs to sign when we pull money out of the trust, okay? Now, a lot of the bells and whistles that go with this kind of trust are the same as the revocable trust. The main difference is who the trustee is. It ain't you, right? It's going to be one of your kids, perhaps, maybe two of your kids, maybe three of your kids. It could be a friend, it could be a nephew, a niece. We've seen it all. The idea of the trust is that we want to protect money for something that may happen down the road, okay? I don't know if you're going to need long-term care down the road. I hope you don't. I hope you never need a nursing home. I hope you never see the inside of them. But it's possible, and it's expensive. So people go this route, and they're going to do this kind of plan to protect their assets just in case. Now, it may not happen. And I'm like a control freak. I have a really tough time if I'm going to give up control of something for something that may never happen. You guarantee a result, okay, right? I'm going to die one day. I'm going to get life insurance so that I know my family's going to get money, because those are guarantees. When it comes to long-term care, I just don't know. Maybe I'm healthy. Maybe I die before I even get to that point. So one of the things this trust has to accomplish is we got to make sure that you still control everything. And this is in a slide. This is the 3 things I want everyone's plan to do when it comes to Medicaid planning and a Medicaid trust, this kind of trust. I want to avoid probate because I know we're all going to die. Let's avoid probate. Let's get money to the right people in the most efficient way possible. Oh, by the way, avoiding probate may just pay for your trust in terms of the equities involved here. Number 2, I want you to protect your assets if you think that's important to you. Not everyone thinks that's important, and that's all right. But if you think it's important, I want you to come up with a plan where not only do you avoid probate, but you're also protecting your assets. And lastly, and most importantly, and this is why this trust works as we get into the next couple slides, you need to control your assets. You need to control everything. Don't give up control for something that might happen. So yes, we do have someone else as our trustee. Maybe it's our kids. But there's going to be lots of good bells and whistles when it comes to this trust. You are still the income beneficiary of your trust. So if there's rental property in there, CDs, stocks, brokerage accounts, you're still the income beneficiary of those assets. If we put a piece of property into the trust, guess who's paying all the bills? Congrats, you are. You're still paying all your bills. Guess who has sole exclusive use and occupancy of their house? Again, congratulations. You still get to use and enjoy your house. So you pay all the bills, you get to live there. It's not that different than it is now. So that means you also still get the star exemptions or enhanced star, okay? One day you may move, you may sell your house. Well, the proceeds of the sale will stay in the trust. It'll stay protected. Well, I want to buy a new house. Go buy a new house. The trust will buy a new house. Well, I want to rent a place in Saratoga. Okay, great. How much money do you need? Well, we'll take money out of the trust if that's needed, okay? When it comes to principal distributions from your trust, that's where it gets a little complicated. But you know what? The amount of money your family saves when it comes to long-term care needs, it's just worth it. If it's a concern of yours, you deal with the perceived difficulties of taking your own principal out. But this is how it works. In New York, if you want to pull money out of your trust, based on the rules of this trust, we're going to need you, your trustee, and your beneficiaries to sign a piece of paper to memorialize pulling $50,000 out of your own trust, okay? That means, in a worst case, we need your trustee who's someone other than you, and your beneficiary, again, someone other than you. And a lot of times it's your kids. So let's say you have 2 kids, you name them both trustee, and they're both obviously your beneficiaries under your plan. If you want to pull your own money out of your own trust, I am saying, it's factually correct, I'm saying we will need the signatures of the trustee and the beneficiary. But that's not asking them permission. A lot of times people say to me, you mean to tell me that I got to ask my own kids permission to get my own money? No, I didn't say that. We didn't say permission. We don't use the word permission. We need the signatures of your trustee and your beneficiaries. And if they don't agree to sign, or if they're out of town, in 2 seconds, we can amend your trust to remove them from existence. So we no longer need their signature. Now, again, remember why we're doing this. We're doing this because unless we have other people who are required to sign, other positions like a trustee, Medicaid's going to take this money. They're going to hold it against us when it comes to our qualification for Medicaid, essentially taking the money from us. So you know what? We name our kid as trustee. We name a third party as trustee. We give things to beneficiaries one day when we die, and we get their signatures when we pull money out of the trust. If they're unavailable or they're unwilling, we change whose signatures we need. You control it. That's the control. You take your ball and you go home, okay? You control all of this, and you could change all of the other parties involved in your own trust until the day you die. So we get to avoid probate, get to protect assets because we do need that third party, but we control everything because we control that third party, and we could replace them with a yes person, okay? So I'm throwing a lot at you. When it comes to Medicaid and it comes to nursing homes, there's a 5-year look back period. So the question becomes, when should I do this kind of trust? And every case is different, right? You shouldn't leave this seminar thinking you need to do a trust or you need to do a will. You should leave this thing thinking, I should probably talk about it more. Maybe I should meet with Dave or Debbie or Jane Marie or Harry, or maybe I should email with questions, right? This is the beginning of a longer conversation for you. But in general, I tell people, once we're hitting 60, it's really time to think about this kind of trust. And it's not too complicated for me to explain why. Medicaid for the elderly, we're talking 65 and older, right? When you turn 60, if you did a trust that day, 5 years down the road, behold, you're 65 and you're in range of the program. Why early? Well, I like it early because I want you to be at your best health. I want the chances that we get through 5 good, healthy years without significant long-term care needs. I want those odds to be extremely high. And oh, by the way, I want to avoid probate. And I want to get things to the right people with the right rules. Right? I don't want to rely on just beneficiary designations. I want to make sure that if heaven forbid something happens to my son, that I have provisions that take care of that in case I never got around to changing my documents. Okay. Now, when it comes to community Medicaid, which we didn't really talk about, so let's do a little timeout here. We have seminars going this whole week. They're 1 p.m. every single day. Tomorrow at 1 p.m., Jane Marie is going to be talking to you guys about community Medicaid if you'd like to join her. Okay, you could contact us or go to our seminar page on our website and click the link to register for that. She's going to be talking about the Medicaid program that doesn't provide care in a nursing home. It provides care at home or an apartment or your daughter's house or wherever the care may take place. Historically, there was no look back period, and actually right now, I can get anyone on this webinar qualified for community Medicaid if they have the need by May 1st. And that's because there's no look back period. I don't have to plan in advance anymore. Right? I don't have to plan in advance at all. But that's not the case going forward. So there was some changes made to the budget in New York State, which lead to this catastrophic change. If you intend on getting home care services in the future, and you apply for those services October 1st this year or later, there will be a 2.5-year, a 30-month look back period on your qualification, and they're going based off of the date of your application, not based off of whether your trust was grandfathered in or not. So even more than ever, it's really important to get ahead of this and to create this kind of trust. Yes, we may never need long-term care, and yes, we may have a very peaceful and healthy life. Wonderful. That life will end one day, and I want you to avoid probate. And I kind of like to start with that because I can't guarantee anything else in life other than that eventuality. So let's be smart about how we get things to people. Let's have a good plan. Now, don't get me wrong. A will is fantastic. Okay, a will gets the job done. Most of my friends have wills, and they haven't elevated the trust yet because statistically, they're probably not going to both pass away anytime soon, right? Husband and wife. So a will gets the job done, and eventually all roads will point to a trust. Now, pros and cons are in the eye of the beholder, right? It's important to avoid probate unless probate's the way I have those rules for my kids, right? There are a couple other consequences that I really want you to take into account when it comes to analyzing what's the right kind of product for me, okay? I really like control. There's options other than wills and trusts to get things to people. For example, there's something called a life estate deed that you may have heard of before. That's where you deed your property to somebody else, your daughter. And in the deed, you reserve the life use. You get to live in your house, you get to pay all the bills. It's a lot cheaper than a trust, right? So why didn't I talk about that? Well, I like control. I like being able to fire my daughter if I wanted to. And when it comes to a life estate deed, it's now her house, only subject to my use. So I have lost control. I can't undo it. If I want to sell that house, I do need her signature. And if she disagrees with me, I can't sell that house. But again, as I mentioned earlier, what you should come away from, what you take away from this, is there's more of a discussion that needs to be had. Like, for example, what assets do you have? I have plenty of people who are renting an apartment in Saratoga or renting an apartment in Catskill, okay, or Hudson. They have a very large qualified retirement account in IRA or 401k. And based on the Medicaid rules, for example, based on what we would put in the trust or not put in the trust, they have no need for a Medicaid trust because their retirement is considered exempt as a asset and will be looked at as income. So it's complicated. Certainly not something to talk about over the webinar, okay? Wills are public. When we deal with estates, they're public. Prince had a public estate, the artist Prince. David Bowie had a very private estate because he had a lot of trusts. Whenever you hear in the news about what Aretha Franklin did in her estate, you know that she had a will. When you never heard anything, it's usually a trust unless there's some sort of litigation for those big stars out there. What's right for you? Again, it's so hard to say over a webinar or over a seminar. It's so asset specific. And when you come to our office, we'll give you about an 8-page questionnaire. So you could fill out to your comfort level, but at least it gears, you know, it sets our sight on the right course for you, the right considerations. If you have, as you'll see, property in multiple states, right? That may not be one probate, that may be 2 probates. It's craziness. So we're really going to want you to avoid probate. If you have multiple pieces of real estate, again, it's really important in our minds to avoid probate. Business assets, a lot of conflict, family trees that are in disarray. You just want things to be private. Obviously, if you're going towards asset protection and we're worried about Medicaid, certainly you're going to want to go with a trust 9 times out of 10, at least. I could say that. I'll check to see if there's any questions. I'm sorry I did all the talking. My wife's used to it by now. We are on the radio every Saturday morning, 8 a.m. to 9 a.m. on Magic 590 and 100.5 FM. And if you're a little further north, you can reach us at 96.9 FM and 1410 AM. We're also available on Sundays in the morning on WBPM 92.9 in the Kingston area. We do free consults. They're not half an hour, they're an hour. We go through lots of things with you. We get to know one another. We answer all your questions. We look at your old documents. It's a long, thorough process because your documents need to be customized for exactly what's going on in your life and for your family. Our attorneys are very knowledgeable. Jane Marie, Debbie, Harry, myself, we all can take care of your needs. We have 4 office locations. We're in Albany, Kingston, Saratoga Springs, and our new office in Clifton Park. Obviously, I'm in the office right now, but most of our staff is not. They're working remotely, and we're doing social distancing as best we can. We have only a handful of people in the office, so we can take care of all your needs. But we're doing most of the work remotely. Our phone calls, if you wanted to talk with me tomorrow, for example, would be a phone call or a video conference. Our document signings have gone more and more interesting. I find myself meeting people in parking lots and handing them envelopes with their legal documents in them, and then they return money to me. It's quite entertaining, actually. But the documents have urgency. The sooner you sign your trust, for example, the sooner your 5 years could start to tick. The sooner your 2.5 years now for community Medicaid starts to go. If you'd like to come to our office once the dust settles, if you want to have a phone call, if you want to have a video chat, what have you, you could email us at info@herzoglaw.com. You can call the office, the main office in Albany, 518-465-7581. Okay. I'm seeing I got a couple chat questions here. Let's take a quick look. We have a question. What happens if you don't make it 5 years? Very good question. So the question is, okay, I set up this trust and I'm planning for more than 5 years down the road, needing long-term care, and lo and behold, I need it sooner. I need it 3 years in. Well, one of the benefits of the trust, and it's different depending on your math, so I don't want to get to into it here, but your worst case scenario is you never do any of this planning, okay? And then one day you need a nursing home. And your loved one comes to our office and they say, Dave, what do we do? And I'll look at the finances, I'll look at the income, we'll figure everything out. We'll say, all right, looks like you have $600,000 with the house and other assets, and you never did a lick of planning. So we're going to do something called a crisis plan, where we loan about half your money and gift half your money in a rather complicated plan. What that will do, big picture, is that's going to save about half your money. It's going to save about $300,000 in my example. It's not going to save the other $300,000. That other $300,000 is going to need to be used for your care. And maybe that gets used up over the course of 2 years or so. Okay. So you never did anything. And we know that we're going to have $300,000 of pain, at least. If you do a trust and you get to the 4-year mark, okay, we're 1 year away. What are we going to do if all of a sudden there's a long-term care need? Are we going to blow up the whole trust, undo it, and settle for losing $300,000? No, we're already 4 years in. So we're going to say, all right, it sounds like if we private pay the nursing home for 12 more months, whatever money is still in that trust at that point will get to 5 years and it'll be protected. So in general, what the trust does is it serves to make your worst case scenario less worse. And until we get to the 5-year mark, I can't say we're protecting everything, but the more money is in the trust, the more protection we are accruing, okay? It's not like if I get to 80% of my assets are covered, right? But it reduces our worst case scenario because we need to private pay for a smaller amount of time to buy us getting to 5 years. And that's where the community Medicaid program becomes so helpful because, you know, anything could happen. People get old real quickly sometimes. So the goal isn't we need 5 years of great health or bust, right? It may be that we have 6 months of good health and then we have some pretty, you know, cruddy health. But at least we could take advantage of the community Medicaid program to bridge the gap, to buy us some time. So we're getting long-term care at home under different rules compared to getting long-term care in a nursing home over with the 5-year look back period. So I hope that answers that. Let's see what else we got here. Oh, there we go. Sorry. Question is, what if you move out of New York State? Why would you do such a thing, move out of New York State? So your trust is a New York trust governed by New York law. It's the shortest paragraph in your Medicaid trust. In my opinion, it's the most important because it's New York law that says that if everyone who's an interested party, if the trustee, beneficiaries, and you agree, you could do whatever you want. You can take all your money out and so on. So those rules are going to go wherever you go. So you sell your house in New York and you move to Arizona or Florida, or stay off the beaches if you're in Florida, by the way, please. You're going to be able to continue to protect your assets. The rules governing how you can get to your money, if you feel like it, will still apply because it's a New York trust governed by New York law. So we're going to avoid probate everywhere, regardless of where you live. So moving out of New York State won't impact you at all. See, we got a couple more questions here and then we'll call it a day. We're always going to be available for email questions as well. I know I got some emails prior to the seminar with people who had some questions. So Ed, you're asking if there are any penalties from the start for having a trust and not making the 5 years. So again, there's going to be a period of ineligibility. If 4 months after you did a trust, we have a catastrophic event and all of a sudden we're talking nursing home, what we will do is we will undo your trust. We'll give everything back to you, and then we'll look at other ways to help protect your money. We'll look at, do you have a spouse? Do we have any children who are disabled? Do we have a child of yours who's been living in your house with you for a couple of years? Because those are all tied to certain exemptions under the Medicaid program. And there we get into something I would call crisis planning. We will talk a little more about crisis planning on Wednesday when we do our state and Medicaid planning seminar. Again, that's at 1 o'clock. We'll do one more question, and then I'm going to thank you guys so much. So the question is, can a trustee be located in another state? And that'll be our final question. So yes, of course. We have trustees all over the place. We prefer if they have access to America, frankly, because a lot of times when trustees may need to do something like create a new account They may need to have their signature notarized. Most of the time they will, or a medallion signature guarantee or something like that. And so ideally, if they're in the 50 states where they could access a notary and be able to scan things and mail things and FedEx things, that would be very helpful. The world's a lot smaller now than it used to be, so it's not uncommon for us to have trustees who live on the West Coast, and then I forget that, and I call them at 8 a.m. New York time, and then they're angry at me because I woke them up at 5 a.m. LA time, but that happens. Thanks so much for taking part. I know a couple people had questions we never got to. Have a wonderful, wonderful day. Hopefully we'll see you tomorrow at 1 o'clock with Jane Marie, and make sure you look at our schedule for the rest of the week. Thanks so much.